Well, good morning, everybody. My name is John Giardinelli, and I'm Association Counsel. I have been asked to bring you up to date on the status of the attacks on the National Association of Realtors and its compensation model. So I'm going to do it in two parts. The first part of this rant, which I am recording on October the 6th in the morning, is going to be on the status of all of the litigation. And then in a short while, probably in about maybe 2.5 weeks, I'm going to record another rant on what all of this means for compensation and for MLS rules and all of that. So we're going to do it in two parts because it would be too long of a rant. So what's going on? Well, quite a bit. The National Association of Realtors, as all of you know, have rules that govern the multiple listing service. And one of those rules is that a seller, when entering a property into the multiple listing service, is required to offer compensation. And while that compensation in some areas can be as little as $0, in your association, it can be $1. What the plaintiffs are alleging is that because no one is going to show a property that is only offering $1 as compensation or any other amount that a member deems unsatisfactory, that the practice in the industry is to offer anywhere between half of the 4 to 6% or somewhere close to that, and that offer of compensation, which is mandated and which as a matter of practice is usually half of a compensation that could be between 4 and 6% to the listing side, adds substantially to the cost of selling a property. Now, I don't agree with that. N.A.R. doesn't agree with that. There are a lot of factors that go into why compensation is set as it is. I believe that the way compensation is set will be substantially changed over the next year or so. And that's what I'm going to go into on part 2 of this presentation. But for right now, I want to talk about how we got here, what's at stake. And so the granddaddy of all the problems is a lawsuit that was filed and has been certified as a class action in the district court in Chicago. It covers a number of multiple listing services, a number of brokerages, a number of other agencies and entities, and the National Association itself. And it alleges that the practices engaged in are in fact discriminatory and antitrust violations. And so what's at stake is, number one, a very large potential settlement and or judgment. Some say as high as $13 billion. Nobody really knows. It's a number. It could be lower, it could be higher, but because it's antitrust, it will be trebled if in fact N.A.R. loses, which could bring the judgment into the $30-40 billion category. So obviously, nobody has that kind of money. We're talking about a lot of very bad results. That particular action is going through some of the earlier stages of litigation. There has been a certification of the class. The class consists of anyone that sold a house in the jurisdiction of the court, which is a very large geographical area, since April of 2015. So a lot of people. The plaintiffs are claiming that compensation is too high due to the N.A.R. rules, which your multiple listing service follows. There essentially are two classes of plaintiffs. One are the damaged financial sellers. Those are people that sold from April of 2015 up until the date of the certification of the class. And then what they're calling the injunction group, which are people that will benefit if the practice that N.A.R. is currently engaged in is struck down by the courts and enjoined. So we're talking about a very big case and a lot of money. Right now, the case is set for a trial setting conference. It's anticipated that the case will probably go to trial sometime in first or second quarter of 2024. N.A.R. intends to file a motion for summary judgment, which is essentially a motion that will claim that there are no factual discrepancies or disputes, and as a matter of law, N.A.R. should be allowed to prevail without going through a trial. That motion is going to be most likely denied, so that kind of in a nutshell is what's happening. What happens when the case is resolved? Well, there'll be appeals, of course. There'll be determinations if a bond is necessary. There'll be post-trial motions. There'll be arguments over the language of the injunction, if any. And of course, there'll be an argument over whether the judgment and or the orders are stayed pending appeal. And so we're looking at probably another 2 to 4 years of litigation. There is a buyer's side case also pending in the same court. And in that case, a group of buyers has argued, wait a minute, it's not the sellers that are being damaged, it's the buyers, because we're paying more because we have to pay not only the buyer's side, which is really not true because most of the time it's paid for by the seller, but we also pay for that with a higher purchase price and a bigger loan. That case was dismissed originally. It was refiled, and there's a motion to dismiss that case that is currently pending. Now, the big news is the case going on in Missouri. It's a much smaller case. It's sort of like the stalking horse. Basically the same arguments. The same arguments are that there are antitrust and price fixing claims because N.A.R. requires that there be mandatory compensation, all of the same basic arguments. That case is set for trial on October 16th. Now we're recording this on October the 6th. That means in 10 days, this case goes to trial. The plaintiffs are arguing that if you look at all of the training materials of all the brokerages, they tell their agents to make sure they offer adequate compensation or nobody's going to show the house. There's a lot of statistics, economic reports, and so on. As I said, the trial goes forward as a jury trial, but in the federal court, it's different. In California, for example, it's a 12-person jury. In the federal court, it's a 6-person jury, and the court has ruled that all of the jurors will be not property owners, but renters, and that is because of the injunction portion of the lawsuit. It will have to be a unanimous decision, and the court has held that if the jury determines there has been price fixing, then as a matter of law, there will be most likely damages, and then the jury will decide on that amount. There have been a lot of pretrial motions trying to keep out a lot of different issues. And again, there are going to be a lot of rulings between now and next Monday. Most of the rulings have been, either favorable to N.A.R. or have not harmed N.A.R. So far, so good. Now, 2 of the defendants, Anywhere, which was Realology, and Remax, have settled. Anywhere settled for $83 million tentatively, and Remax for $55 million. A motion was filed to approve that settlement, and that motion was filed on October 5th, yesterday. It is a 43-page motion, and it also includes language that says that if approved, which will take a few months, more than likely, if approved, RE/MAX and Anywhere will no longer require that their brokers join N.A.R. That joining N.A.R. will be up to the individual broker. And in California, there is no requirement that you belong to a realtor organization. That means they won't be bound by the code of ethics, and there'll be certain other issues relating to the multiple listing service. So we're going to be tracking that settlement very carefully, but in the meantime, we're also going to be looking at the trial, because as of right now, Keller Williams, Berkshire Hathaway, and the National Association of Realtors have not settled. So there's going to be huge impacts potentially on associations, because if it's determined that I don't have to be a realtor, if it's determined that the MLS has to make changes, that's going to affect how the associations operate and educate their members. Certainly going to have some impacts on members, particularly as to how you offer compensation, how you get compensation as a buyer's side agent, which is what I'm going to talk about at the next rant session. And of course, there's going to need to be some changes to the law. California, for example, has a statute that defines a multiple listing service as an organization that shares data about properties for sale or lease and has a unilateral offer of compensation. If the unilateral offer of compensation is no longer mandatory, then there will have to be changes to the statute. I'm not going to go into any great detail. I'm going to be flying into California, and on October the 17th, I'm going to be doing a membership meeting, and I'm going to talk about another issue that's come up, which is that as a result of these lawsuits and as a result of some other issues going on at the National Association of Realtors, Redfin has announced that it will no longer allow its brokers, except where necessary, to become realtors. For example, in a state like Tennessee, where you must be a realtor to join the MLS, they'll be allowed to continue. But in states like California, all the Redfin agents are not going to follow the code of ethics. They're not going to be realtor members. They're only going to be multiple listing service members. And for reasons I'll talk about the next time, it's a very dangerous proposition and probably very short-sighted. But I'll go over all the Redfin stuff the next time I see you all. And then in addition to the lawsuits, there's a couple of other things you should be aware of. The Department of Justice was investigating the National Association of Realtors for some of the same issues that we've already talked about that are in these lawsuits. N.A.R. settled that case in what I thought was a favorable settlement. Essentially, the Department of Justice agreed that it would drop all investigations into clear cooperation, into mandatory offers of compensation and all of that. In exchange, N.A.R. agreed to change some of its MLS rules. You've already seen those rule changes. You can no longer advertise as free. You can no longer search by compensation only. The buyer side compensation is already now transparent, and so forth. And so all that's already not an issue for CRMLS members, and so already taken care of. Well, when President Biden took office, his Department of Justice reneged on the settlement and said, well, we're not going to go forward with it. N.A.R. said, well, you don't really have a choice, people. You've settled. We've signed a contract. The National Association then filed a motion to enforce the settlement, and the trial court agreed. Said, you know, that you can't simply change your mind on the settlement, and they wouldn't allow N.A.R. to renege, or excuse me, the Department of Justice to renege. That case is up on appeal. The Department of Justice has filed what is essentially an 86-page motion asking that they be allowed to move forward on investigations regarding mandatory offers of compensation, clear cooperation, marketing practices of MLSs and members, and so forth. It's very, very expensive, as you can imagine, to respond to these subpoenas and And so N.A.R. has filed its own motion, and we're waiting for the judge to decide to enforce or not enforce the Department of Justice settlement. There's also a potential at the Federal Trade Commission. They've been asked to look at your business practices as well. And there's a number of other issues that are pending all around the country. So I think you get a pretty clear idea that there are there's a lot going on. Now, that's going to have an enormous impact, no matter what happens, on things like how you offer compensation. Will it be mandatory? Will negotiations take place between sellers and buyers directly, between sellers and buyers agents directly? In other words, basically a sub-agency kind of a thing. We're going to talk about that at the next rant and on October 6th, 17th at the Lone Wolf Lodge. So until then, it's John Giardinelli, and we will see you down the road. Take care.